Good morning, everyone. Thank you very much for inviting me to participate in this conference. It really is such an honor and privilege, as many others have said, to be a participant and engage in the ways in which whiteness as property informs both our historical understanding of racial domination, but also the ways in which it is relevant today in contemporary civil rights debates. I teach property law, immigration law, as well as critical race theory, and this semester I have the privilege of teaching property and race. It's a 2-credit seminar, and on the first day of class I assigned whiteness as property. And it really, from one of my students' reflective papers to her, it was mind-blowing and highlighted for her a lot of the questions that she's had throughout her law school curriculum or classes about how to better understand the way that law has shaped social relations today. And so thank you, Cheryl, for writing this very important work. The title of my talk is, in parentheses, White Citizenship as Property. So, white citizenship as property. During the time allotted to me, I aim to show the power of whiteness in helping us to better understand two immigration and citizenship issues of our time. One of these issues is well known to many of us, and the other is lesser known, virtually marginalized, yet I argue is also extremely important. The first issue deals with the exclusion of 11 million undocumented immigrants from formal membership in our American polity, rendering them to hide in fear in the shadows of immigration law, or what I call the undocumented closet. The second focuses on the second-class citizenship status of the over 4 million citizens who are living in the U.S. territories. Both these legal questions about citizenship, lack of formal membership for undocumented immigrants, and denial of equal membership for U.S. territorial citizens are rooted in racialized exclusionary immigration and citizenship policies that were historically invested in creating a white nation and limiting citizenship to whites. Importantly, both these issues are made possible by Congress's plenary power over immigration and citizenship, as well as its plenary power over the U.S. territories, which are both recognized under the Constitution and given legal force by U.S. Supreme Courts and lower courts. The failure to recognize these historical and judicial origins, in my view, would severely limit the development of meaningful and just resolution to these current issues. To begin, how does whiteness as property inform the ways in which we can understand the issue of lack of membership for undocumented immigrants and second-class citizenship for territorial residents today? As a starting point, it is helpful to note how citizenship itself may be considered as a form of property. Cheryl Harris noted in Whiteness as Property that the modern conception of property is that it's not about one's relationship to a particular thing, but rather it refers to the relationships among people, social relations among people with respect to a particular thing. And as she explained, law legally constructed whiteness as extremely valuable, as a valued resource that facilitated racial domination and subordination that continues to the present day. Well, I argue that whiteness as property helps us understand the propertization, borrowing from Peggy Radin's talk last night, of citizenship along whiteness. There should be no doubt that one of the most valued resources in the United States, historically as well as today, is citizenship. Here, by citizenship, I mean formal membership to the American polity. Citizenship, as many of us know, may be acquired by birth, either by being born in the United States or by being born to at least one parent who is a U.S. citizen. The other way that citizenship may be acquired is by naturalization. Possession of citizenship generally means the acquisition of other bundle of rights, including the right to vote and participate in the jury system, both of which manifest the right to use and enjoy the valued property of citizenship. And although you cannot alienate it, that is, you cannot sell citizenship, it is one that you can pass on to your children. Importantly, the ability to acquire citizenship intertwined with legal preferences for whiteness in ways that excluded people of color and immigrants from acquiring citizenship. And as I hope to underscore, Such racial exclusion from citizenship was made possible in large part through Congress's plenary power over immigration and the territories. Let me first begin with the right to naturalize to U.S. citizenship and how that relates to our current population of undocumented immigrants. As the Supreme Court recognized in Che Chang-ping in 1882, Congress has plenary power over immigration. Che Chang-ping, of course, upheld the Chinese Exclusion Act, which was a law that barred the ability of Chinese from entering and immigrating the United States. It was not the first exclusionary immigration law that based on race. The 1875 statute, the Page Act, that it's a law that excluded the ability of certain groups of people, including prostitutes, from entering the United States, was intended to limit the ability of Asian women to immigrate to the United States. So from 1875 on to at least 1952, Congress passed several measures to exclude the ability of Asians to enter the United States. One of these laws was the 1924 Johnson-Reed Act, which May Nye has argued was used in order to create a white nation. And that is because Congress explicitly excluded the ability of certain groups of Asians to enter the United States. It also prohibited the ability of people who were not eligible to become citizens from similarly immigrating to the United States. And this is where immigration law then worked alongside with citizenship laws during this period in order to continue to create a barrier along the United States and ensure that the country was perpetuated a white nation. In particular, only certain groups of people between 1790 until 1952 were eligible for citizenship. From 1790 until about 1870, only whites were eligible for citizenship. After the Civil War and the passage of the 14th Amendment, then those of African descent were also eligible to naturalize, unless, of course, they were born here in the United States. Until that time, until specifically 1943, only whites and those of African descent were eligible for citizenship. That means that for those groups of people who were able to somehow break the barrier of immigration laws that excluded them because of their race, they were unable to become U.S. citizens here in the United States through naturalization. On the other side of this coin was this ongoing allowing of Congress of Europeans, particularly those from the northern part of Europe, to immigrate to the United States. So on the one hand, Congress was preventing certain groups of people, particularly Asians, from immigrating to the United States, and on the other hand, allowing thousands of Europeans to enter our country. In so doing, creating this controlled immigration law that was designed to ensure the whiteness of our nation. In 1965, the Hart-Celler Act finally lifted national origins quotas that Congress had set in place to limit immigration laws. And in 1952, Congress also prohibited laws that excluded people from becoming U.S. citizens on the basis of race. So ultimately then, Congress did, at least formally, lifted these racially exclusionary immigration as well as citizenship laws and ensured that people have some type of equal access to become citizens. But that's not necessarily the case. The 1965 Act was a law that, as Hiroshi Motomura argues in his new book, Immigration Outside the Law, continues to be a law that is highly selective. Very few people are actually able to immigrate to the United States based on employment. If they have family ties to the United States, the paradigm that it created continues to bar thousands and thousands of immigrants from reunifying with their families. Today, there is a backlog of between 15 to 20 years between the ability of a person to actually, in applying for family-based immigration, to actually arriving in the United States. So 20 years of backlog separation between families. And if you recall, for those of you who have taken immigration law, family unification continues to be the official policy, at least one of the important policies of immigration law. So what does this history of exclusion under immigration as well as citizenship, how does that relate to our contemporary issues of undocumented immigration population today? What Congress has done in 1965, I argue, failed to take into account this history. In seeking to open the doors, immigration doors, and saying now everyone is welcome, it failed to take into account the thousands of people who were excluded at the door to begin with. If Congress had created some type of race-conscious measures to ensure that the Filipinos and the Mexicans in particular who were excluded at the outset, then perhaps we might not be in the current situation of a backlog today that has compelled many people to cross the borders, particularly to come here in order to be with their families. In the interest of time, I'd like to switch over to the second issue that I wanted to highlight, and that is the second-class citizenship of people who are residing in the U.S. territories. And in the spirit of critical race theory, I would like to share a story. Lenny Tuaua was born in American Samoa in 1951. In 1969, Tuaua moved to Daly City, California, where he attended college and subsequently sought a career in law enforcement. He scored very well on his entrance exams for California Highway Patrol and the San Mateo County Sheriff's Office. However, he was deemed ineligible to join the state and county law enforcement offices because Tuaua, despite being born in a U.S. territory, is not a U.S. citizen. Instead, people who are born in American Samoa acquire the status of non-citizen national or U.S. national. Thus, at birth, Tuaua, like his parents and grandparents, who were also born in American Samoa, is a U.S. national. As non-citizen nationals, American Samoans owe allegiance to the United States and are thus recognized as members of the American polity. The Immigration and Nationality Act does not apply to them because they are not, quote, aliens. Indeed, they have U.S. passports, and thus they do not need visas to enter the United States. Perhaps importantly for many non-citizens, American Samoans can never be deported because, after all, American Samoa, a U.S. territory, is part of the United States. But as evidenced by Tuaua's exclusion from the San Mateo County Sheriff's Office that requires citizenship as a job requirement, he and other American Samoans are clearly not U.S. citizens. Indeed, it's not only public employment that has been unavailable to them. As non-citizen nationals, American Samoans are also ineligible to vote in federal, state, and local elections. They are unable to serve on a jury, bear arms, and participate in federal programs, such as federal work-study programs while in college. Thus, tired of feeling like second-class citizens, on July 12, 2012, Tuaua and other American Samoans filed a lawsuit against the federal government and sought a declaratory judgment from the court that they are U.S. citizens. Specifically, they contend that under the Citizenship Clause of the 14th Amendment, they acquired citizenship at birth in American Samoa. The Citizenship Clause provides that, quote, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States. Tuaua claims that American Samoa, which is subject to the jurisdiction of the United States by virtue of it being a U.S. territory, is part of the U.S. for purposes of the Citizenship Clause. As such, he and other American Samoans born in that territory should be regarded as citizens. His argument thus far has been rejected. In Tuaua versus United States, the court agreed that, yes, indeed, American Samoa satisfied the first requirement and held that American Samoa is subject to the jurisdiction of the United States. However, relying on the insular cases, a line of cases in which the U.S. Supreme Court had held that not all parts of the U.S. Constitution applies in U.S. territories, the court concluded that America is not part of the United States for purposes of the Citizenship Clause. The court noted that because American Samoa is an unincorporated territory, a territory that has yet to be placed on a path to statehood, then only fundamental constitutional rights are extended to its inhabitants. Critically, the court held that citizenship is not a fundamental right in these U.S. territories. It is not the only court that has held this, that has concluded this. The Second, Third, Fifth, and Ninth Circuits have also reached similar conclusions in cases in which Filipinos, when they were U.S. nationals, have also argued unsuccessfully that they should be recognized as U.S. citizens at birth. In sum, this case highlights for us yet another instance in which exclusionary measures under the U.S. Under citizenship, as constructed by Congress and given force by the courts, continue to subordinate and marginalize the ability of certain groups of people, particularly people of color, from being considered members of the American polity. So just to briefly conclude, one of the questions that we ought to ask here is, where do we go from here? Right? That is one of the big questions that we have in this post-racial society. I argue that in order to get to there, we need to understand our racial past and the ways in which both immigration and citizenship laws, as given power by Congress's plenary power, continue to exclude people of color from citizenship. Thank you.